No, this is not concerning you all. All right, thank you.
What paperwork? Did you sign paperwork? It shows that you signed it already.
All right, everyone. If you're not a part of any hearing, I'm going to ask that you please mute because I'm getting a lot of feedback from your end. And just give me a moment while I set it up. And it's turning out to be a Monday because we do not have AC. I think people are liking the rain now.
I did not realize we were without AC.
There is no AC.
I wish I would have known that before going to the gym.
Thank you. All right, thank you.
This is Sunny. I'm not sure who I need to speak to. The inmate got his paperwork for the consent to video and an appeal, but he did not get the plea paperwork. I signed it, but the jail saying they don't have it.
All right, then what I'll do is I'll send you to a breakout room. Who was doing the paperwork for you?
I had,
It was me, Judge.
oh, there you go.
All right, so I'm going to send you and Joe Ray to a breakout room. And I'll send you to breakout room number 2
Thank you.
with your client, and we'll find out where your paperwork is. All right, everyone. Sorry. Everyone, just give me a moment.
Come back tomorrow. I'm waiting to sign. How does that work? Do I have to sign paperwork and stuff like that? How long would that take?
Mr. Severn,
Yes, ma'am.
my understanding is that we've had some issues with your behavior at the jail.
No, ma'am. But I mean, they're gonna be relieved what they say anyways.
Oh, no. This is what I'm telling you right now.
Yes, ma'am.
I'm going to treat this as though this is my first time.
I can't hear nothing, Miss Boyd.
It always like makes me I guess
Yes. Mr. Severn, unmute for me, please.
Is that on mute?
Yes.
Okay.
All right, Mr. Severn,
Yes, ma'am.
my understanding is that there were some issues at the Bexar County Jail with you. I'm not taking that to be true. No facts have been presented to me. But what I'm telling you is I do not want any behavioral issues. We're all adults here, okay?
Yes, ma'am.
All right, so I want you to be patient and just wait right there. I will be right back.
Yes, ma'am.
I'll be back. Are we on mute?
Meredith, are you a co-host? No.
No, I'm not. I probably should be.
Oh, there you go. Thanks, Judge.
Joe Ray, I think I am. Do you need something?
gosh, it's hot as all get out. All right, and everyone, I'm going to take off the robe. We don't have any AC in here, and it is hot as all get out in here.
Is there a timeline on turning back on the AC?
Tom, why are you acting as though you're not dealing with the government? Why are you acting like this is your first day and it's the first time you work with the government? I don't know when we're going to get AC, but I know it's 100 degrees in here.
Joe Ray, are you there?
All right,
Yes,
so
I'm
the
here.
parties on.
Yeah, it's not coming up for him. He can't find it.
Okay, so if you guys
If you want to send it back to me, I'll sign it again and do it again.
All right, so everyone, we're going to go on the record on Mr. Michael Hepler. Who are the parties on Michael Hepler?
Sorry, Judge, I was hearing Sonny Middleton. Which case?
Michael Hepler.
I'm on that one, Judge. Hunter Morris on Hepler.
Yeah, Judge, that's my case.
All right, we're going to take that out.
So- Hey, Sergeant, can you call me back? I'm in a hearing.
Again, everyone, please make use of your chat.
Right.
And I'm sorry, I'm not in my robe. We don't have any AC and it's 100 degrees in the courtroom. The court is going to call 2019 CR 7668, State of Texas versus Michael Hepler. Could I have parties announced for the record, please, for the state,
Hunter Morris for the state.
for the defense?
Luis Martinez on behalf of Mr. Hepler.
And let me see what, Mr. Hepler, could you unmute for me, please? I need you to unmute, sir.
Yes, ma'am.
Thank you. We're proceeding by video because of the pandemic. Any objections from the state?
None from the state, Judge.
Any objections from the defense?
No, Judge, we've indicated that in writing.
Mr. Hepler, did you sign a document entitled Defendant's Consent to Appear by Video?
Yes, ma'am.
Did you understand it and did you review it with your attorney?
Yes, ma'am.
The court will find that the defendant has knowingly and voluntarily consented to appear by video. Next, Mr. Hepler, I'm going to show you two documents. One is entitled Motion to Revoke Community Supervision. The other is entitled State's Motion to Supplement Motion to Revoke Community Supervision. Did you review that document with your attorney and did you understand it?
Yes, ma'am.
Are you the same Michael Anthony Hepler who was placed on community supervision in 2019 CR 7668 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on October 31st, 2019 for a period of 6 years? Is that you?
Yes, ma'am.
State?
Condition number 41, on or about the 23rd day of October 2020 in Bexar County, Texas, the defendant, Michael Anthony Hepler, then and there failed to comply with the rules and regulations of the felony drug court by engaging in the distribution of a controlled substance in violation of condition 41.
How do you plead to that? True or not true?
True.
State would waive and abandon the remaining allegations.
Any objections to the state's waivers?
No, Judge.
Mr. Hepler, did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, and sentence you to 6 years in prison? Did you understand that?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes, ma'am.
Court will find 41 true. Is there an agreement?
Yes, Judge. The state would ask to reform the judgment to 3 years, revoke, send for 3 years, and take into consideration night mag number 612654.
Is that the agreement, defense?
Judge, that's our joint recommendation. We're asking the court to follow that recommendation.
Mr. Hepler, are you asking the court to follow that plea bargain agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
Court will follow your agreement. As previously stated, the court is finding violation of condition number 41 true, sentence you to 3 years in the prison, give you credit for any time served. Take in consideration night mag number 612654. Next, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Hepler, you have decisions you need to make in your life. Either you want to end up in prison for the rest of your life or you do not. Do you understand?
Yes, ma'am.
All right, Norma, can you let them know that Mr. Hepler can go back? He's
Yes,
listed on the screen as L10.
Yes, ma'am.
Right, who are the parties on Damien Estrada?
Meredith McIntyre for the state judge.
Amir Memori for Mr. Estrada. Judge, you're muted. It shows that your mic is muted.
Yes, but everyone can hear me. Thank you though for
Okay,
letting me know.
okay. Just want to
I
make sure.
appreciate that.
Yes, sir, that's good. That's good. That's good. That's.
All right, the court is going to call 2019 CR 6518, State of Texas versus Damien Estrada. Can I have parties announced for the record, please, for the state?
Meredith McIntyre for the state.
For the defense.
Amir Memori for Mr. Estrada.
Are you Mr. Estrada?
Yes, ma'am. Yes, Your Honor.
Proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor.
Mr. Estrada, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Damien Estrada who was placed on deferred adjudication in 2019 CR 6518 for the offense of aggravated robbery on January 29, 2020 for a period of 10 years? Is that you?
Yes, Your Honor.
State.
Violation of condition number 2, on or about the 12th day of January 2021 in Bexar County, Texas, the defendant, Damien Estrada, did then and there illegally use marijuana in violation of condition number 2.
How do you plead to that? True or not true?
True, Your Honor.
State.
State waives the remaining violations.
Any
No objections.
To the state's waivers. Any objections?
No objections, Your Honor.
Mr. Estrada, did you understand by pleading true to violation of condition number 2, the court can find it true, grant the motion, find you guilty, and sentence you up to life in prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, Your Honor.
Court will find violation of condition number 2 true. Is there an agreement?
There is, Your Honor. We're asking this court that you deny the motion, continue him on deferred adjudication, alter and amend his conditions to include intensive outpatient treatment and 60 days of weekly UAs.
Is that the agreement?
Judge, it is our agreement, and we'd ask the court to follow it, please.
Mr. Estrada, is marijuana the only drug that you've been using since you've been on deferred adjudication?
Yes, Your Honor.
Why are you using marijuana when you know you could go to prison for life?
It's just a stupid mistake, and it's just something
No,
that
it's not a mistake. You made a choice.
Yes, ma'am. It's just a stupid choice, and I really.
So why are you making stupid choices? How old are you?
20 years old, ma'am.
You're 20.
Yes,
You're
Your
on
Honor.
deferred adjudication for aggravated robbery. From here on out, any decision you make, you need to ask yourself, is this a decision where I could potentially end up going to prison for the rest of my life? You understand?
Yes, Your Honor.
I don't think you want to be at the Bexar County Jail and somebody asks why you're here and you're like, I'm here because I'm smoking marijuana. I know how some people feel about marijuana, but in Texas, it's still illegal.
Yes, Your Honor.
Can't smoke marijuana, use marijuana, or even drink alcohol while you're on probation. You understand?
Yes, Your Honor.
All right, I'm gonna deny the motion, alternate amend conditions to include intensive outpatient treatment. There's gonna be weekly reporting by Zoom. Are you able to Zoom?
Yes, Your Honor.
There's gonna be weekly reporting by Zoom until further notice. And there's gonna be the UA hotline until further notice.
Yes, Your Honor.
Judge, what was the second part of that?
The UA hotline. So they'll be calling him when they want him to take a UA. All right, is there anything else from either side?
Judge, I just wanted clarification for Mr. Estrada myself. So he's going to
Yes.
be reporting by Zoom every week to the court, correct?
No, he'll be on Zoom reporting to probation weekly.
Probation, I'm sorry.
And Mr.
And
Estrada,
then-
Estrada, you are able to Zoom, is that correct?
Yes, Your Honor.
Yes.
Judge, and as far as the Zoom with probation, will they get in touch with him on how to email him and let him know when to come in?
Yes, they will.
Okay, and then Judge, second part on the UA hotline,
Yes.
does that mean that once a week they will contact Mr. Estrada and have him provide a random UA?
Not so much once a week, but they can call him at any time. But they
And how many
usually
hours-
do it like a day.
And how many hours will he have to report to provide that UA, Judge?
They'll let him know.
Okay, I just wanted clarification. So, Mr. Estrada, do you understand what's going on here, sir?
Yes, yes, Mr. Raham.
Okay, I just want to make sure that you understand that the court is working with you and wants to address the issues. So you've got to make sure that you work with the court and you report weekly by Zoom and then provide the UAs when they call, okay?
Yes, sir.
Judge, we greatly appreciate your time and effort in this and also thank Meredith with ADA's office, Judge.
All right, thank you. And Amir, what I'm gonna do, I'm gonna send your client to a breakout room. Probation will join him shortly. And Mr. Estrada, I'm gonna send you to breakout room number 3. And probation will join you in a moment.
Judge, am I excused?
Yes, you can be excused, or if you would like to go to the breakout room with him, you can.
Yeah, let me go out to the breakout room with him, Judge, please.
Yes. And let me find, yes, I sent you to number 3 as well.
Thank you.
All right, who are the parties on Cecilia Alvera?
Hunter Morris, Judge.
And who's
Cristina Mendiola, Your Honor.
defense?
Cristina Mendiola.
All right, the court is calling 2019 CR 6454W, State of Texas versus Cecilia Alvera. Could I have parties announced for the record, please, for the state,
Hunter Morris for the state.
for the defense?
Cristina Mendiola for defendant, Your Honor.
All right, and Ms. Alvera, could you unmute yourself, please? Are you Ms. Alvera?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the defense?
No.
No objection. Your Honor.
Any objections from the state?
None from the state, Judge.
Ms. Alvera, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you
Yes.
understand it? And did
Yes,
you
ma'am, I
electronically sign it?
Yes, ma'am, I did.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Everyone, just give me one moment, please. Ms. Ferguson, I've signed the documents on Enostrosa.
What am I saying?
What's the question?
Okay. Ms. Alvera, I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am, I did.
Are you the same Cecilia Saucedo Alvera who's placed under deferred adjudication in 2019 CR 6454W
Yes.
for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on June 12, 2019 for a period of 2 years? Is that you?
Yes, ma'am.
State.
In Bexar County, Texas, the defendant Cecilia Saucedo Alvera did then and there fail to report to the supervision officer in person for the months of September and October 2019 in violation of condition number 5.
Are you clear? Is that true or not true?
Yes, ma'am.
Now, how do you plead to that? Is it true or is it not true?
True.
State.
State waives and abandons the remaining allegations.
Any objections to the state's waivers?
We have no objection, Your Honor.
Ms. Alvera, did you understand by pleading true to violation of condition number 5, the court can find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am, I do.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there an agreement?
Yes, Judge. 1 year extension, deny the MTR, a new TAP evaluation, and then intensive outpatient treatment.
That is correct, Your Honor. That is the agreement.
All right, Ms. Alvera, are you asking the court to follow that agreement?
Yes, please.
All right, so why are you not reporting?
It was a lot of things. There's no excuse. I messed up that time.
Are you able to Zoom?
Yes, ma'am.
All right, the court will follow your agreement, deny the motion, alternate amend conditions to include 1 year extension, a TAP evaluation, intensive outpatient treatment with probation, and weekly Zoom reporting for 2 months. Is there anything else from either side?
Nothing from the state, Judge.
We rest as well, Your Honor.
All right, thank you. I'm going to send you to a breakout room. Probation will meet you in that breakout room. It'll be breakout room number 3.
Thank you.
Rebecca, you can go to 3.
Thank you, Judge.
I agree with you, Your Honor.
Yes. All right, Ms. Alvera, I'm just trying to find you on the screen. There you are. If you could go to number 3 for me, please, Ms. Alvera.
Yes, thank you.
All right, we're going to go on the record on Mr. Severin. All right, the court is calling 2018 CR 1670,
And then number 30.
2018 CR 11669, State of Texas versus Lorenzo Servin. Can I have parties announced for the record for the state? And this is a case where the defense is asking to withdraw.
100 more for the state.
For the defense? Mr. Garcia, could you unmute for me, please?
Yes, ma'am. I want to re-urge my motions to withdraw, Your Honor.
All right, are you retained on this case?
Yes, Your Honor.
All right, Mr. Severin, can you unmute, please?
Yes, ma'am.
Your attorney wishes to withdraw from your case. Are you in agreement with that?
Not really, but I mean, it is what it is, you know?
No, let's not do it is what it is, because people, when they say it is what it is, nobody knows what it is. So my question for you is, your attorney wants to withdraw from your case. Do you have any objections to that?
Yes, ma'am.
All right,
I feel like I know that I didn't make the right choice this last week. by not showing up to my court meeting. And
Just time out for one moment, Mr. Severin. Mr. Garcia, have you spoke with Mr. Severin about your motion to withdraw?
No, Your Honor. No, I wasn't able to get a hold of him. They didn't find him till Saturday.
Okay, so what I'm going to do, Mr. Garcia, I'm going to send you to breakout room number 1 with Mr. Severin.
Judge, once again, I have an inherent conflict.
Mr. Garcia, I understand what you're saying, but your client legally has to be given notice, and he hasn't been given any notice that you want to withdraw. Now, be that his fault or somebody else's fault, you know, it is what it is.
Given the circumstances, it was impossible, but I'll do it, Judge. I'll join them in the room.
All right, Mr. Severin, you need to go to breakout room number 1. All right, and everyone else, the court has not received any other paperwork. Luis Martinez, you're waiting for Mr. Wheeler?
Yes, Judge, we've executed all the paperwork.
To the clerks in the back, do you have the paperwork for Wheeler?
And Your Honor, you signed the paperwork for Mr. Enostrosa.
Judge, can you put me in the breakout room with Enostrosa?
I'll go with the shit. Mr. Enostrosa, if you can go back to breakout room number 2, please.
Thank you, Judge.
Deputy. We're going to start with the jury at 2:30. Would you like? At 2:30, you're going to have to come back later in the day. So everyone, please get all your paperwork together. And Mr. Martinez, I'm going to send you to breakout room number 2 so they can let you know where your paperwork is. And then on DebNet, I'll let you all put your objections on the record, and then I'll make my ruling. So we're going to go back on the record in 2019 CR 6484. I'm going to have parties announced for the record for the state.
Marcus Sanders for the state.
Tom Nisbet for the state.
John Young for the defense.
All right, the jury is not present in the courtroom. The state, my understanding is you wanted to admit an exhibit. What is that exhibit number for the record, please?
23 and 24.
And defense, have you had a chance to review state's exhibits 23 and 24?
I believe I've reviewed 23, Your Honor.
Garrett. Okay, so the record's clear. The defense reviewed states 23, the body camera SAPD officer Garrett, and then states 24 is a body.
24. There's no objection to your client's statements, correct?
Correct, Your Honor.
All right, so then that part will be admissible most definitely, since you have no objection to it. What are you objecting to then?
I'm objecting to the portion that the state has redacted already, at least in one version of this, which is the officers' comments in their discussions and their questioning and discussions with my client of his prior criminal history.
Yeah, that's up.
All right, so that objection, my understanding, that objection will be sustained, and my understanding is that has already been redacted. So
That is my
any
understanding also,
history
Your Honor.
related to your client is sustained. And
Then the other portion would be the commentary from the various officers among themselves. And also with some witnesses, not witnesses, but some bystanders that have walked up and have had discussions with the officers and the officers' discussions with the witnesses who have already testified here today.
well, let's take it one at a time. So the commentary with the officers, state, are you offering that commentary?
No, Judge, what he's referring to is in the probably latter 2/3 of the video. They're making charging decisions. Of course, we're aware of what kind of stuff that is. No, we are not offering that
All right, so
audio.
that objection will be sustained, and it's the court's understanding that the state is not offering it. So the other objection you have, and these were discussions that both the state and the defense had with the court off the record, is statements from witnesses who previously testified. Is that correct?
That and also with bystanders that wandered up.
So let's address the bystander issue. State.
Not offering. Those would be, I guess in theory, legal theory, witnesses that we are not calling, and we are not proffering anything they said on these videos.
All right.
Also redacted.
So that will be sustained, and the court will note for the record that the state is not offering that. So then that leaves the witnesses who testified. Is that correct?
Correct, Your Honor.
All right, what is the defense's objection to the witnesses' audio or video statements in State's Exhibits 23?
It would be both bolstering and also that it is largely hearsay because they're making statements that, as we've noted from their cross-examination, they did not actually witness. They were responding of what someone else had told them.
All right, the state, here are you?
Just unpacking those objections, it is not bolstering because we are not offering it on the direct of those witnesses prior to them being cross-examined in court. The rule's pretty clear. He crossed them in court. He attacked inconsistencies, which thereby attacks credibility, whether defense counsel wants to say it does or not. Those are fact questions for the jury now. So not bolstering. Dovetailing with that, then it becomes a prior consistent statement, which we are allowed to use with these witnesses who were subject to cross, testified in court, complied with Crawford, said previously. And then going to the hearsay or the underlying issue of indicia of reliability to overcome hearsay, you can see both in the timetable of the videos, the prior testimony as a predicate, or their demeanor in the video. It's both an excited utterance and a present sense impression. As the court heard the 911 call earlier, and police are arriving while they are still on top of the defendant. And from that moment, you will see the officers run up in Garrett's video. So you have excited utterance, present sense impression. It is bolstering, but they have been attacked. Ergo, it's a prior consistent statement. And those reasons, Judge, are why we are offering those statements.
All right, the defense counsel's objection to that part of the video will be sustained. Is there anything else from either side with regards to State's Exhibit number 23?
No, Your Honor.
All right, State's Exhibit number 24. What is the objection?
If it is the redacted version, Your Honor, no, the different officer, it would be the same objections to those items in that video.
What specifically is in the video of State's Exhibit number 24 that you have objections to?
The officer's commentary, which prosecution has assured me that they're going to redact. The witnesses, not witnesses, the bystanders that came up the statements from the prior witnesses. And if there's anything on there from my client, we are not objecting to that. We are objecting to the rest of the comments.
All right. State.
I mean, every argument is the same, Judge, on the prior video as this one.
All right. So with regards to commentary, then my understanding is that the state has already said that they will redact officer commentary as far as what will be charged. So that would be sustained. The state has stated that they would redact any bystander commentary. So that will be sustained. And the other one would be
The three prior witnesses, Your Honor.
that would be sustained. All right. Is there anything else from either side?
No, Your Honor.
All right, the jury's going to come back in at 2:30. And we'll go off the record on this case. Is anyone ready on Roland Garcia? Did you speak with Mr. Severin?
Yes, Your Honor, and I informed him that I was withdrawn from his cases.
Could you please go back to breakout room number 1 and ask your client to come to the main room?
For me to go back and tell him to go to the main room? Okay. Okay.
Raphael Leal, where are you?
Right here, Judge.
What is happening with your client?
Well, Your Honor, I filed a motion for production of CPS records that I like to set for a hearing. I had just been appraised that there is CPS records in the case that I like to review.
No, we've been doing CPS records since March.
I do not understand, Judge.
Since March, you've been asking for CPS records. And I showed that on May 7th, the court said, yes, you're to have the CPS records, and all it took was for you to go to the office to pick them up. So have you done that?
I have requested that and I was denied that, Judge, that I needed to file a motion, and I did.
When did you file this motion? Because this has been going on since March.
Well, I mean, Judge, this morning, right away, I asked Mr. Garcia for those records, and I talked to the advocate, and Mr. Garcia appeared to not have a problem with me getting those records, but I was just informed that I needed an order of the court.
Counsel, I understand what you're saying, but what I'm telling you is you're needing the CPS records has been going on since March. And I know that each time people are told, file a motion requesting the CPS records. So we can't come back, March, April, May, June. We can't come back June 7th and we still haven't filed a motion. And every day it's the same thing. I need CPS records.
Judge, my understanding is that you have already rolled on it, and Mr. Garcia indicated that that I could pick him up once I coordinated with the advocate, and I did that, and that's when I was informed that I needed a court order. I thought we had an agreement at the very least to get those records without the need to do anything else.
All right, Ms. Ferguson. Victor Vela. Norbert Ferguson.
2:30. I'm going to be done by 3.
Yes, ma'am.
Victor Vela, give them a 3-week reset. Mr. Leal, this is your plea deadline date. The court will not accept any plea bargain agreements after this date. Could I have a 3-week reset, please?
Yes, ma'am.
This is becoming.
They can come back on July the 7th, Judge.
All right, we'll be back on July 7th. And Mr. Leal, after that date, the court will not accept any plea bargain agreements.
Judge and Mr.
July the 7th,
July 7th.
9 o'clock?
Yes.
Okay.
and
All right.
Mr. Leal, sorry, Judge. Go ahead.
Yes. Go ahead, Joe.
I just wanted to make it clear, they're available to view in the office, and they've been available.
Well, I mean, I need a copy of those records to review in my office. And that was the reason that and you said that they were in a CD that I could pick up earlier today.
Time out. You all can discuss this off docket, Mr. Leal. The records have been waiting since March. So whatever you all need to do, Mr. Leal, then you can make that happen. The state said they're willing to be available. They're at the office. They've been at the office for you to view. What I'm telling both parties, and I want them to know, July 7th, that's your plea deadline date. The court will not accept any pleas after that date.
Judge, my motion has to do with the production of the actual records physically by CD, through a.
I know what your motion has to do with. What I'm telling you, Mr. Leal, is that this has been going on since March. This is an old case. However you all want to do your records, that's fine with the court. July 7th, that's the plea deadline date. And so we're moving on. Mr. Garcia on Lorenzo Sermon.
Yep.
I'm sorry, could you unmute, Mr. Garcia?
Excuse me. Pardon me, Judge?
Yes. All right, did you have a chance to discuss with your client your motion to withdraw?
Yes, Your Honor.
All right, and you still wish to withdraw?
Yes, Your Honor.
All right, Mr. Sever, could you unmute, please?
Just right now. Well, yes, ma'am. Being that I don't have the $3,000 that I paid him to bond me and represent me.
You're not here with me to review your contract that you read with Mr. Garcia. My only question for you is, do you object to Mr. Garcia withdrawing? Yes or no?
Yes, ma'am.
All right, Mr. Garcia, why are you asking to withdraw? Roland Garcia, why are you
It's hard, background noise, Judge. It's hard hearing you.
That's okay. Mr. Garcia, why are you asking to be allowed to withdraw?
Because of an inherent conflict, given the fact that I was Mr. Sesbeen's bondsman, and he failed to show up in court.
All right, the motion to withdraw will be granted on both cases.
Thank you, Your Honor.
You're excused. Mr. Servant, are you going to be able to afford to hire an attorney, or do you need one appointed to you? Could you unmute, please?
I need one appointed, Judge.
All right, just give us a moment.
Yes, ma'am.
All right, I'm going to send you to breakout room, Mr. Severn. And I'm going to send you to breakout room number 3. And Ms. Ferguson, if you could go to breakout room number 3, please. All right, the court does not have any other documents. If I did, we would proceed.
Judge.
Yes.
This is Rafael Leal. I think we're at an impasse with the production of those records, Judge. I think I have to request a hearing to get that ruled out.
How are we at an impasse? All you have to do is file the motion you want filed. The court will review it. The court will sign it, and you will have the record. So what is the impasse? I don't understand.
Well, I already filed a motion, Judge.
Well, the court does not have the motion. If the court has the motion, then the court will sign the motion.
Okay,
And when was this motion filed?
electronically, Judge.
When?
Oh,
What day?
today.
All right, so why do you think I would have a motion today? And again, this has been going on since March. And the court is just receiving a motion for CPS records.
I thought we had an agreement, Judge, that was expressed even today. It was reiterated that we had an
Well, I
agreement.
mean, the agreement is always with CPS records that you're allowed to go to the office. and view
Production,
those.
Judge, for production. That was the agreement. But I would appreciate if the court will rule on the motion as soon as possible so I can pick them up.
Yes, as soon as the court has the motion, the court will sign those motions.
Thank you. Judge.
I will make your priority my emergency. So as soon as I have that, I will sign it.
Thank you, Judge. Appreciate it.
You're welcome. All right, anyone else?
Yes, Your Honor, this is Ms.
Coming back
Middleton.
in 5 minutes. Yes, Ms. Middleton?
Just for information, you have already signed Mr. Enostrosa's plea paperwork for today. Did you want us to come back, or how did you want to handle that?
To the clerks, where is Mr. Enostrosa?
He's in jail.
No, I mean, why don't I have his paperwork? All right, everyone, give me a moment. Because I have patience in my
Judge.
pocket, I'm gonna go
Judge,
to the back to get paperwork. Yes.
We need to swear in the defendant. Can you put us in the
Well,
breakout room?
that's why I sent him to the breakout room to be sworn in. He was in breakout room number 2. Mr. Enostrosa, go back to breakout room number 2 and they will swear you in.
Thank you, Judge.
Yes. Unfortunately, I look even shorter and fatter without my coat on, so.
But we have no AC. And Brenna, they don't know when we're going to get it. Yeah, I'm gonna get a.
Well, Mr. Severin apparently is still working on the video.
Oh, we're gonna remove everybody. All right, everyone, I'm gonna send you to breakout rooms. You need to go to those breakout rooms, please. Excuse me, just one moment, everyone. Thanks. Okay. Ms. Middleton, I'm going to send you to a breakout room with your client. Mr. Enostrosa, if you can go back to breakout room number 1, and as soon as we can take you, we'll take you.
Thank you, ma'am.
You're welcome. Thanks for your patience.
Yes, Your Honor.
Go back to number 1.
Yes, go to number 1.
Okay.
All right.
John, I don't know what's on your screen, but what's on the
Yes.
screen there? And
Yes,
on
I'm going
that
to take care of that. Just give me a moment. Thank you. All right, everyone, please be seated. All right, everyone, as you can see, I have other cases that are in no way related to this case because we still have a full docket. So please pay no attention to that. And we're going to go back on the record and state, if you could call your next witness, please.
The state calls Michael Tovar.
And everyone, you'll notice it's a little hot in here. We have no AC. So I'm continuing to keep my robe on, but I'm opening it a little bit because it's 100 degrees. But if anyone needs to take a break, or if you need a water break or something, just let us know. All right, if you come forward, please. Would you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, if you could have a seat, lower your hand, and please do not touch the microphone. If you could state your name for the record and spell it, please.
Michael Tovar, Michael-Tovar.
Right. And if you could make sure you keep your voice up.
Okay.
All right, state.
Thank you, Judge. Mr. Tovar, do you live here in San Antonio?
Yes, sir.
Where do you live currently?
Currently living in Alamo Ranch area.
How long have you lived there?
8 months now.
Prior to that, where did you live?
I lived on northeast side on Hillsborough Drive.
And what do you do for a living?
I'm a tattoo artist.
So back in April 27, 2019, would you have been living at Hillsborough Drive?
Yes, sir.
Do you remember what your street address was?
9606 Hillsborough Drive.
Were you involved Are you aware of a shooting that took place on April 27th of 2019?
Yes, sir.
How did you become aware of it?
I heard the gunshots outside. Sent my wife to go get the children. She notified me that there was people on the side of the house. Went outside to the side of the house, couldn't see anything, heard a lot of shuffling. Went inside, grabbed a flashlight. Upon going back outside, when I went out, shined a light, I came on the scene and, well, my neighbor was attempting to choke.
Let me break it up a little bit.
Okay.
So you heard the gunshots, and where did it sound like they were coming from?
In between my house and my neighbor's house, to the left of me.
And what were you doing at the time that you heard the gunshots?
Watching a movie with my fiance.
Okay. And so you heard the gunshots and you went outside?
I had ran to the backyard first because it sounded like it was in the backyard.
Okay. Was there anything going on in the backyard?
Nothing in the back.
So then you went where?
I went to check on my children. Fiance notified me that she heard a lot of shuffling and yelling on the side of the house.
Okay. So did you go outside?
I went outside, didn't see anything, went back inside, grabbed a flashlight, and that's when I started to witness everything that was going on.
Okay. So when you went outside with your flashlight, what did you see?
Immediately going outside, shined the light down. My neighbor, he was attempting to choke the guy that was there. When I shined the light, I noticed that there was a gun in his hand. So I went and stepped on his wrist.
Let me stop you. You noticed there was a gun in whose hand?
And this gentleman over here, sir.
Okay. And so the person over there, is that the person that was
Yes, sir.
on your yard April 27, 2019?
Yes, sir.
Okay. And so you said you shined the flashlight and you saw your neighbor. Is your neighbor Michael Cruz?
I didn't know his name, but I believe it's Mike.
Okay. Did you learn after the fact what his name was?
Yes, sir.
Michael had the defendant in some sort of chokehold?
I wouldn't necessarily a choke, but he had him in a headlock.
Okay. And was he saying anything?
For me to help him.
So when he said, hey, can you help me? What did you do?
I disarmed the gentleman that he was attempting to choke.
How did you disarm him?
I stepped on his wrist, pulled his wrist back, and took the gun out of his hand.
Do you remember which hand is the gun?
It was in the right hand.
Was the brother out there when you went out there?
I informed him to stay down because I saw he had been stabbed in the leg. So I had him sitting on the floor.
And so you took the gun from the defendant's hand, and what did you do?
I went and placed it on my porch.
What did you do next?
I waited for the cops to get there.
Prior to that night, I think you sort of answered this, but how familiar were you with your neighbors?
The most we said was hi, a slight wave every now and then, but I had never formally met them.
Have you had any contact with them since you moved?
No. Though when I saw them upon arrival today, that's about it.
Did you all discuss the case after it happened?
No, sir.
Pass the witness, Judge.
Right. Defense?
No questions, Your Honor.
Right. Is this witness subject to recall or is he excused?
Excuse.
All right, the rule has been invoked. What that means is you cannot discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state and attorneys for the defense. Do you understand?
Yes, Your Honor.
All right, thank you for coming in. State, call your next witness.
State call CSI Andrews. Oh, it is Emler now? Okay.
All right, if you could. All right, if you could take a seat here, please.
Take that with you. Yeah, thank you.
All right, if you could raise your right hand for me, please. Do solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God. Yes, ma'am. All right, you can lower your hand, and if you could have a seat, but please do not touch the microphone. Okay. And if you could state your name for the record and spell it.
Am I okay to take off my mask?
Yes.
Okay. Catherine Emler, Catherine, last name Emler, M as in Mike, Ler.
State?
Thank you, Judge. CSI Emler, how are you presently employed?
I'm employed as a crime scene investigator with the city of San Antonio.
How long have you been employed in that capacity?
Just over 5 years.
Any training that goes into that particular role with SAPD?
Yes, sir. We, when we're hired, we take 400 TCOL approved hours of training. Over the years, you just take refresher training to maintain your skill set.
Okay. And just generally for the jury, the type of things that you learn in that training are?
Well, my role as a crime scene investigator is to document, collect, process evidence related to the offense that we're working. So the training is geared towards that, to go through those steps to complete that.
Okay. When you are called to a scene, generally your duties are?
My duties are to first find out what happened. Based on that information, we document the scene. If there's evidence to be collected, we'll collect it. And if there's any additional processing that needs to be done, then we'll complete that as well.
Okay. On April 27th of 2019, were you on shift?
Yes, sir.
Okay. And did you make a shooting scene that evening?
Yes.
All right. May I approach the witness, Judge?
Yes.
First, I'm going to hand you what has been marked as states number 25 for identification and ask you if you recognize that document.
Yes, sir.
And what is it?
This is my report.
Okay. How do you use that report in conjunction with your job?
This report basically itemizes my actions on scene and the items I collected, what processing I completed, and also gives me, provides a brief summary of what I was advised on scene.
Okay. I see you brought a large brown paper bag with you to court today. Let's start with just the outer bag. What is that bag?
The outer bag is really just a facilitator to carry the evidence that's inside of it.
Okay. And the contents of that bag generally are?
The items that I collected that night.
Okay. And these would be the items marked with E, letter E, and then a number corresponding to your report.
Yes, sir.
Okay. So let's start with item E1, please. And I have gloves if you need them and scissors if you need them too.
This is E1.
Okay. Item E1 on your report is what?
It's
CSI Emler?
It's a Vortec pocket knife.
Okay. So what I'm going to do is mark the outer bag as states 26 and place an exhibit sticker on the front cover now and ask you, if you flip the package over, please, are there any unique letters corresponding to a badge number on this outer packaging?
Yes, so there's my initials, my badge, and I also put the date at the time of packaging.
Okay, and so the jury knows you put that stuff on there for what reason?
To identify that I packaged this.
Okay, and so item E1, could you take, I don't know if you like a knife or scissors, your choice, but
scissors.
Let's break the evidence seal on that package at this time, please. Let's take a peek down there. Okay, so item marked for the record, states number 26 is an 8.5 by 11 manila envelope. Within it is a piece of wrapped, I'm going to say 8-inch by 3-inch brown cardboard. Would you please cut this open, CSI Emler?
Your Honor, we would object to the further involvement of this knife in this case. It's irrelevant to the charge.
State.
First of all, it's contextual, and I would reiterate my arguments of if the defense has cross-examined the lay witnesses and is challenging the truthfulness of the story, this will be a physical piece of evidence which matches all three, excuse me, at this point, all four witnesses prior given testimony.
All right.
So it would be relevant.
All right, that would be overruled.
Yeah.
Okay.
But when you open it, just keep it down because I can put a sticker on it.
Okay, no problem.
So just looking at the contents of what is in this brown cardboard box, do you recognize the contents of this container?
I do. Mhm.
And are there unique markings on this physical exhibit in here?
Yes.
Does this fairly inaccurately depict E1, the exhibit you collected on the night in question?
Yes, sir.
Okay, I'm gonna put a 26A on that. I'm going to offer 26A into evidence pending any defense objection.
Any objections?
Same objection, Your Honor. It's irrelevant.
All right, that will be overruled. State's Exhibit 26A is admitted.
Thank you. Your description of states 26A in your report is what? CSI Island.
E1, one Wartech pocket knife with a 3.5-inch blade.
This is, I guess, by style, a lock blade knife.
Yes, sir.
All right, let's continue into your bag with E3, please.
Okay.
All right. E3, if you could tell me, does this bag contain your unique markings, badge number, and date?
Yes, sir.
Okay, could you, if you could please take the scissors and break the evidence seal on it at this time. For the record, the CSI is cutting into a new 8.5 by 11 manila envelope that I will label as States 27. Sorry, you're good. Thank you. Okay, how many pieces do you have? All right.
And that's gonna be the fire.
Yeah. All right, so within that package, there are 1, 2, 3, 4 remaining packages. All right, so I'm going to mark the matchbox as States 27A, contents inclusive, the 2-inch by 4-inch manila envelope with States 27B, contents inclusive. Let me see, that is 5 by 7?
It's a 6 by 9.
6 by 9, thank you. The 6 by 9 with States 27C inclusive, and then finally the square brown paper bag with States 27D inclusive. Would you cut each of these items open for me, please?
Sure.
Don't show them yet, but you can look.
Yep.
Yeah.
Okay. Pull it out or?
Yeah, just to verify if it's the same one you
Okay.
selected.
Okay.
That's I guess globally, I need you to verify and testify, are each one of these physical items, 27A through B, the same that you collected at this scene on this day at this time?
This item in the cardboard box, I'm assuming this is from the crime lab. I'm not sure. This is not something I collected that night.
Okay. Are there,
I can.
yeah, can you cut it open and look at the individual exhibit inside?
Oh, it is. Yeah.
Excuse me. With the heat, does anyone need any water or anything? Because they brought some down from upstairs. Could you let the deputy know that some of the jurors are asking for water?
No, sir.
And if I believe it's cold.
Yeah. Yeah, it just says this is all from the crime lab.
Oh, that's from the crime lab.
Yes, excuse me. Tom, if you could just give us a moment, please. Deputy Laura, some of the jurors are saying that they need some water. All right, everyone, just give us a moment. Sorry about the heat. I've just been told that the coolers are down in the courthouse. So hopefully tomorrow they will have some sort of ventilation for us.
Judge Boyd, I just ran across the supervisor and manager of facilities, and they notified me that they just turned them on. They were able to fix them, but
Okay.
it's still going to take about an hour or so.
All right, thank
Okay,
you.
You're welcome.
Oh, good.
Thank you.
So maybe tomorrow.
Thank you, Your Honor.
Thank you. Okay, all right, so everyone, we're back on the record.
Thank you, Judge. So CSI Emler, what we had marked, or what I had marked, pardon me, as 27A had markings for the Bexar County Crime Lab.
Yes, sir.
And although you don't work there, you know those markings to be the firearms and tool mark section.
Right.
So
Yes,
for
sir.
the record, I'm going to set that aside and focus our attention with this witness on states 27B, C, and D. Do the items contained in these three packages match those that you collected at the scene for this case that night?
Yes, sir.
Thank you, ma'am. Judge, pending objection from the defense, we're going to move 27B, C, and D into evidence.
Your Honor, you wouldn't believe that I was actually a medic in the Army, and I used to put these things on pretty easily.
Okay.
Okay, this is, which one?
D.
D. Never given it to me, Tom. No objection, Your Honor.
All right, then that states 27B, C, and D. Is that correct, state?
Yes, Your Honor.
All right, then states exhibits 27B, C, and D is admitted.
Thank you. The record and the jury are clear. We're looking into the contents of states 27C. These are individual items that I'm placing out on the witness rail here. CSI Emler are what?
Live rounds.
Live rounds, okay. Just, I guess, live means on fire.
Correct. Yes,
All
sir.
right. This little item right here, CSI is what?
The magazine.
Okay. The item, I don't want to keep this in anybody's. Item I'm holding here, CSI Emler, is what?
Firearm.
Okay. Did you document in your report the make, model, et cetera, of this firearm?
I did.
Okay, and what is it?
I have it reported as a DB9 firearm. Serial number
Sure.
is YE4369.
9, just for the members of the jury, refers to.
The caliber.
Thank you. And then our last package, which is states 24, the contents are one item. This item is what?
It's an apparent spent shell casing.
Spent means fired?
Yes, sir. Fired.
All right. Can you pull out E5 for me, please? Yep. And so my first question for E5 is, does that contain your unique markings, badge number, and date?
Yes, sir.
Thank you, ma'am. Let me put a sticker number 28 on it. Thank you. Can you break the outer package now, please? Okay, and the contents of states 28 are a, what size was that again?
This is a 6x9.
6x9 white envelope. I'm gonna mark that 28A. We don't need to open this one. Can you just tell me, is that envelope, the envelope and its contents, the one you collected on the night in question?
Yes, sir.
Just a second. Pending any objection from the defense, we're going to move 28A into evidence under conditional admissibility. We are, however, not going to testify to any theoretical results until such time as the correct predicate has been laid.
There's nothing for me to object to.
But because I have to move this one exhibit in now. Chain of custody, I suppose.
Any objections subject to the proper predicate?
Yes, Your
being
Honor.
laid?
No proper predicate's been laid for its admissibility.
Could I have parties approach for a moment?
Yes, sir. Okay, thank you, Judge. This different size envelope, what is that? Is that a kit?
Yes,
Okay, what is a kit for?
it's a gunshot residue test.
And a gunshot residue test is applied out at the scene by who?
Myself.
Okay. So let's walk the jury a little bit through the procedure. I'm going to take these hot gloves off. Let's walk the jury a little bit through the procedure of how you apply a gunshot residue test.
Okay. Yes, sir. So this kit comes with 2 vials. One's left hand, one's right hand. I'm left-handed. I usually collect the left one first. It's just habit. It's a sticky pad inside. You just dab the hand. Outside of the hand is preferred, up the arm. The webbing is the areas that you're applying the sticky pad to. You do that for both hands. It does come with a questionnaire on the inside. I attempt to ask the questions if I'm able to.
Okay, so hypothetically, you are a CSI, you arrive on scene, a detective or someone says, hey, look, there's Tom over there. We think Tom shot a gun. You're going to use one of these kits. You're going to take out some type of sticky pad. And could you just show the members of the jury for me?
Implies like this.
Okay.
And if I may add, this kit does come with an additional set of single-use gloves that I put on very first.
Your Honor, when she turns to the side and talks to the
I'm sorry.
prosecutor, I can't hear her.
I'm sorry.
All right, and could you make sure that you just speak about?
Oh, okay. Yes, ma'am.
And then it goes into, you said a vial?
Correct. The vial has a cap. You close the cap on the vial and I place it back into the envelope.
Okay, all right. Thank you. In this particular case, referring to report on E5, could you tell the members of the jury who the gunshot residue test kit 28A was performed on and sent for testing?
This gunshot residue test was conducted on Kevin Dednam at 2350 hours on the night of 4/27/19.
Okay, and at what address does your report state?
9602 Hillsborough Drive.
Thank you. Thank you, ma'am. Judge, we passed the witness.
Thank you, Your Honor. All right, is it correct to address you as officer or what?
CSI.
CSI,
Yes, I'm not
okay.
an officer, so.
When you did the gunshot residue test, did you test one person or more than one person?
I just conducted one test that night.
Now, you usually test who the detective on the scene tells you to test,
Right.
correct?
Yes, sir.
And so you didn't check Michael Cruz that night, did you?
No, sir. I didn't collect any additional GSR.
Did you check either Michael Cruz or Mr. Debnab's face?
No.
When you dab, do you do a squeezing motion at the same time?
No, sir. It's a hard plastic, and the sticky pad's on the bottom, and only the sticky pad is applied to the surface.
Okay. And so you use the same sticky pad on all the places on that hand and arm that you checked.
Right. So if it's the left side, that entire sticky pad's used for that side.
Okay. And I'm not sure how far your expertise goes in this, so I'm going to ask the question anyway. What is gunshot residue?
Gunshot residue is what is essentially comes from when a gun is fired, the particles in the air as a result of it, but that's about the extent of my knowledge on that.
All right. I noticed there was only one fired cartridge. Did you see anybody else trying to find any other cartridges?
Yes, sir. The one I collected was actually still in the firearm. We searched the scene, myself, as well as Detective Burrows, who was the another detective on scene, as well as some of the officers. We searched the scene, attempted to locate additional casings, but we did not locate any.
No further questions, Your Honor.
Judge, we have nothing further for this witness. Maybe she please be excused, and I would have to do the evidence release form, I think, with the court reporter as well before the CSI can leave.
Yes. Is she subject to recall, Mr. Young?
I have no requirement for her, Your Honor.
So the room has been invoked, but that means you're not allowed to discuss your testimony with anyone except for attorneys or state attorneys for the defense.
Yes, ma'am.
But you'll be excused, and Brenna will take care of.
Thank you.
All right, state, call your next witness.
The state calls Officer Jeffrey Garrett.
All right, if you'll take a seat here, please. Would you raise your right hand for me? You solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can have a seat. Please do not touch the microphone. And if you could state your name and spell it for the record, please.
My name is Officer Jeff Garrett. That's JEFF GARRETT.
All right, and I'm gonna need you to make sure that you speak up so that the jurors can hear you and also the defense and state can hear you.
Yes, ma'am.
All right, state.
Thank you, Judge. Officer Garrett, how are you currently employed?
Full-time police officer, working East Patrol,
What agency do you work for?
San Antonio Police Department.
How long have you worked for SAPD?
It'd be 7 years and 5 months.
And you said East Patrol. What area of San Antonio is that?
My district area is around Foster and 78 area. And yeah, 4320 district.
How long have you worked East Patrol?
About a year.
Where did you work prior to that?
North Patrol.
And what part of town is that?
North Patrol is pretty much from where the quarry's at up to Marshall Road, and then maybe Northwest Military over to Parambital.
How long did you work there?
Maybe five years or so.
What was your shift back in 2019
I worked a T shift, which was 5 p.m. to 3 a.m.
And are you a certified peace officer?
Yes, sir.
What are some of your duties as a certified peace officer?
Patrol our normal beat, prevent crime, respond to calls of service.
And did you respond to a call on April 27th of 2019?
Yes, sir.
What was that call for?
I believe it came out with shooting in progress.
Do you remember the address for it?
I do not, sir.
Did you make a report from that night?
Yes, sir.
Your Honor, may I approach the witness?
Yes.
Let me show you what's been marked as State's Exhibit B. Is that a copy of your report?
Yes, sir. Smart report.
Okay, so you can use that to refresh your memory, but make sure you don't read that right in front of it.
Yes, sir.
So what was the address that you were dispatched to?
Your Honor, I would object to the officer reviewing the report unless he states on the record that he does not remember something and needs to refresh his recollection.
All right, that'll be sustained, State.
Do you remember the address where you were dispatched to?
So it was 9602 Hillsborough.
Okay. And you said you were dispatched for a shooting in progress?
Yes, sir.
When you arrived at, how long did it take you to get to that?
I don't recall, sir.
When you arrived, were you one of the first ones on the scene?
Yes, sir.
What did you see when you got there?
When I got there, I saw one or two individuals holding down what was who was a suspect at the time. And go ahead, sir.
Do you recall what the person they were the person that they were holding down? Do you recall what he was wearing?
He was wearing black clothing and was wearing a backpack.
Okay. And there were two individuals on top of him?
Yes, sir. One or two.
Was there a weapon that you noticed at the time?
When I approached, I wasn't sure who it was, but someone was yelling from the yard saying there was a gun over there, but I was approaching the suspect at the time.
Okay. So what did you do once you approached?
I placed handcuffs on him, sir.
Was he still wearing the backpack at that time?
Yes, sir.
I guess after you put handcuffs on him, what did you do?
I just stood by waiting for responding officers to get there. And once the first officer got there, I advised them that I was told there was a gun over by the porch area. And I just stayed with the person I handcuffed until I was relieved.
Your Honor, may I approach the witness?
Yes.
What's marked as State's Exhibit 29 through 32. Can you take a look at those? Do they fairly and accurately depict the scene on April 27th of 2019?
Yes, sir.
And at this time, would you offer State's Exhibit 29, 30, 31, and 32?
Defense, any objections?
Just one moment, please, Your Honor. No objection, Your Honor.
All right, State's Exhibit number 29, 30, 31, and 32 is admitted.
Officer Garrett, was this how the defendant appeared on the night?
Yes, sir.
And State's Exhibit 31, is that the backpack that he was wearing?
Yes, sir.
Also 32?
Yes, sir.
And so after you stood by with the defendant, did you have any other role in the case?
I stood by with the defendant, and eventually we unhandcuffed him and took the backpack off of him. And at that time, I walked the defendant to the patrol car where I searched him before placing him in the patrol car.
Your Honor, may I approach the witness again?
Yes.
Show you what's marked as State's Exhibit 33, 34, 35, 36, 37, and 38. Can you tell me if you recognize those?
Yes, sir.
And I guess, are they fair and accurate depictions of the items on April 27th of 2019?
Yes, sir.
At this time, they offer State's Exhibit 33 and 38.
Your Honor, may we approach?
Yes. If you could mute, please. All right, ladies and gentlemen of the jury, there's a matter that I need to take up outside of your presence. Again, you've heard some testimony and some evidence in this case. You are not to discuss what you've heard with each other or with anybody else. You're not allowed to start deliberating. You're only allowed to start deliberating or discussing what you've heard with each other once I give you permission to do so. Does everyone understand? All right, everyone, please rise for the jury. Deputy will show you out. All right. And do we need the witness for his objections?
No.
All right, the rule has been invoked. What that means is you can't discuss your testimony with anyone except to speak to attorneys for the state and attorneys for the defense. If you could wait outside, please.
Yes, ma'am. You want me to take my stuff with me?
You can leave that there. Yes. Oh, everyone, please be seated. All right, so defense has objections to states 30, what numbers, please?
I believe it's 33 through 35, Your Honor, initially.
All right, so objections to 33, 34, and 35. Let's start with 33 then. And for the record, 33 is being shown off the overhead. Defense, what is your objection to 33?
I don't see any relevance to it, Your Honor. It's looks like a bill or receipt from somebody named Graff.
Okay, and would your objection to state's exhibit number 34, if you could show state's exhibit number 34, would that be the same objection?
Yes, Your Honor.
All right, and state's exhibit number 35?
Yes, Your Honor. That's a debit card. It looks like.
Okay, so.
Or not, I'm sorry, a credit card.
So your objections to 33, 34, and 35 is?
Relevancy, Your Honor.
All right, and are there any other exhibits that your objection is relevancy?
Your Honor, I must admit, I did not bring my magnifying glass, so I have a little trouble seeing what these things are. It looks like there's a social security card and I guess a minor's driver's license. There appears to be one document here that has my client's name on it. That, again, I would say it appears to be a relevancy issue.
Okay, so which exhibit? So.
36,
Yes.
and I believe, is it 37? No, that's 37, and that is my client's document. I don't know where that was obtained, but, and then number 38, which appears to be the same documents that we had in 36.
So 33, 34, 35, and 36. Let's take up first the exhibit that you said has your client's name on it. What exhibit is that, State?
37, Judge.
Okay, State's exhibit number 37. What is your objection to that?
Relevancy, Your Honor. I don't know what it's going to be used for or what the reason for it being admitted is.
All right, let's address State's exhibit number 37 first. The objection from defense is relevancy.
It shows ownership, it shows knowledge and ownership of the contents of that wallet and that backpack. But the argument for all of this stuff is all intertwined. So if you'd like to hear it, I will tell you why all of that is both relevant and highly probative.
Yes.
All right. So by way of proffer to the court, the defendant in his custodial statement claims self-defense. Okay, that he was unfairly attacked by two dudes. He did not have a gun, which the court has heard thus far in their theory of the case, and thus had to stab the second guy in self-defense. As the court is aware under the statute of self-defense, there are two presumptions. One is to reasonableness and one is to no duty to retreat. But in order to be entitled to both of those presumptions, under the self-defense statute, which if a scintilla is raised, that's reversible error. We are pretty confident the court is going to give them in that instruction at this point, right? If we get there, and I'm proffering to the court, that's his custodial statement, and we're going to put it into evidence. So I'm putting before the court that that is going to be out there in front of the jury. I'm just, as an officer of the court, I'm putting that out there. The state gets to and has to attack those two presumptions in its case in chief, right? We don't have to wait till rebuttal. It's part of our duty to prove the action and disprove the self-defense. Those are our burdens. To attack those two presumptions, we can show somebody was violating more than a Class C misdemeanor at the time of their behavior and are not entitled to those presumptions. It's very clearly in the self-defense statutes. So argument A, number one, is the defendant is committing the felony offense of possession, fraudulent, at least under 5 items of other people's IDs, driver's licenses, credit cards, social security cards. He's got a bevy of other people's stuff. Okay, so under our attack during our case in chief, which we are legally entitled to and must do during our case in chief to prove our case, we must rebut those presumptions. All right, that is our first argument. We have a second argument which goes to link and knowledge. The second argument, Judge, and this is not a one is better than the other. This is they both apply. So the court is clear on our position. Our second argument is the defense's position here is the defendant didn't have a gun, never touched a gun, never fired a gun. I think that's clear to the court by their theory of the case thus far. We are going to show that that gun does not belong to the Cruz family, right? You heard testimony they own a Ruger. We're going to prove that that gun belongs to the Graff family, and it was stolen from their car prior to this incident, I think in the same week, right?
4 or 5 days before.
That gun was stolen when that credit card and that mortgage application were stolen. And those things were found in this man's possession, which links him in possession to that weapon and rebuts their defense that he never had a gun or never touched the gun. It shows the fact finder, it allows the fact finder to decide
whether they believe that link puts the gun in his possession. Because I would ask the court, if you assume arguendo their position, that Cruz or brother produced that firearm from that stolen gun from Mr. Graff's car, somehow by the bizarre twist of fate in the universe, he ends up in their front yard with the same stuff stolen from that burglary 4 or 5 days later. That's crazy, but that fact issue has to go to the jury.
All right, defense?
Despite the rather snide comments from the prosecutor, Your Honor, that evidence that they're attempting to rebut has not been presented to the jury. Well, the only witnesses so far are his witnesses. And we believe that this material evidence that's been submitted is irrelevant at this point. There's no showing that this is the same firearm. There's no charge for him having documents. There's no charge for him having a burglary charge. At this point, this appears to be an attempt to slander him when there is nothing to fight against. It's not there. If he testifies and brings these things in, then we may very well have these documents admitted, Your Honor. But at this point, they're irrelevant. Second, under a 403 bouncing test, this would be very, very relevant if it were those things and they were proven to be those things, at which point it would be unnecessarily prejudicial compared to the value of the evidence.
We're not offering it just to slander. I have explained to the court, there is a very probative link theory for both possession of the weapon as well as what we have to do in our case in chief.
Well, here's the thing. The court doesn't know what's in his statement because it hasn't been admitted. So at this point in time, the court doesn't have any information that those exhibits that the state wants to introduce are relevant to this defendant. Now, I do see where the exhibit that has his name on it, that is currently relevant. And if the state is going to offer in his statement, and his statement that he gives somehow makes it relevant, but right now I don't see how that's relevant with the information that I have.
Well,
like what has been presented right now to make that relevant.
So we're looking at it kind of like a chain of custody as well, right? There's a second piece to each of these arguments, right? The second piece to the Graff family is Mr. Graff. He will testify. But if the stuff's not there for him to testify about, we haven't finished our first link in the chain, right? We will play the defendant's statement. But if the stuff's not there ahead of time, then so we're putting these things in, not to slander the defendant, but just so the court is clear, he does have a theft of firearm open and pending in this court that this lawyer is on for that firearm. So that's kind of not true. But we are putting down the first link to then link it to those other things later in our case. We're just on witness 4 or 5 or whatever, we're getting there, but we have to do one first in order to get to the other.
So wouldn't that be accomplished by laying the foundation for those exhibits and then presenting them when they become relevant?
Court's preference. I mean, we could admit them conditional admissibility and say, no talking about them right now, no showing them to the jury. They stay with the court until such time as the other half of it's been proven, or if the court wants to keep them out of it. We just don't want to run into a situation where we're circling the witness back around.
I don't see how the state would be circling a witness back around if state's exhibits 33 through 38, if part of the foundation was laid through whatever witnesses it's laid in, and then whatever evidence the state has that makes those exhibits relevant, then that's presented, and then the defense will either have objections or not have objections, and the exhibits will be admitted or not admitted. But at this point in time, I take what the state is saying, that you're presenting it as an officer of the court, and I understand But at this point in time, there's no relevancy for the admission of that evidence. Otherwise, it's just photographs from something that was or was not with the defendant at that time.
Well, the other thing, do you have the one where the contents of all the backpack are laid out?
Mhm.
Did we try that one? Oh, okay.
Your Honor, number 37, I just realized when I was looking at it now, yes, it has my client's name on it, but it's a booking photo. It's a mug shot. And we would object to that also on 403 balancing. Whatever relevance it has, it's much more damaging
If I could
and
see
unreasonable.
State's Exhibit number 37 again, please. Oh, if I could see it up close. Marcus, I wear glasses. All right, State's Exhibit number 37 does appear to be a booking photo.
And I don't know what reason in the world he'd have that in his backpack, Your Honor, and it obviously is him. It was obviously in his backpack, but at the same time, it has ramifications far outweighing this case.
We don't need all the information that's on it. Frankly, a piece of paper with his name on it gets the job done because that shows knowledge and
Well,
possession of what's in the bag.
For 37 then,
If you want to take
if we can do a redaction, and that is remove the booking time that's listed on it. Are you all able to do that? So remove that, remove where it says suspect information. And when I say suspect information, I just mean the title suspect information. The rest of it will remain. And remove in the top right-hand corner on 37 where it says Verapic mugshot. Is there anything else, Mr. Yeah.
I didn't realize what it said until I saw it on the big screen. Your Honor. So you close these
Yes.
excised.
Your client's name
Booking
will
time.
remain. The booking time, that will be removed.
why we're not showing them this right now.
The information will remain, but the title suspect information will be removed.
Okay. I mean, that's something to do.
I'm assuming that we have what is almost obliterated anyway, and then booking time. And then
Just let me see for a moment, Mr. Young. So what is going to be removed is where it states your client's name, Kevin Debnat, will remain. On the left side, upper left corner, where it says Verapic mugshot, that will be removed. The seal that's on the right-hand side, upper right corner, will be removed. The title suspect information will be removed, but name, date of birth, age, that will remain. The section where it says booking time, that will be removed. The date will be removed. Case number will be removed.
thank you, Your Honor. I withdraw my objection based on those corrections.
All right, then 37 will be admitted with the redactions.
I think it's gotten hotter in here.
It has, and they said they were putting on AC, but I don't think that's
So the
happening.
person that was in here earlier and told us that they turned the air conditioner on.
All right, and then state with regards to 33, 34, 35, 36, and 38. You'll have to lay the foundation to show that it's relevant.
Okay.
Yes.
Yes.
And
Do you want to do it with a Sharpie? I don't have a Sharpie. I just have this.
I don't know. I don't know.
this. What you're asking is I redigitize this and put little black boxes on it. I'm just doing it sharp.
So are you going to then withdraw? Or either, Brenna, he can withdraw 37. So you can withdraw 37. You offered it.
Your name would have to spin back.
So just withdraw 37 and make it 37A. Yes.
Judge, the state would move to withdraw exhibit 37.
All right, that'll be granted without objection from the defense.
No objection, Your Honor.
All right, so it was.
All right, is there anything else from either side?
Well, I guess, Judge, now that I don't know if I should get the witness back in. There are some other items that were found in defendant's possession that I guess I would lay the foundation for.
Yeah, just lay the foundation, and you can lay the foundation with this witness in front of the jurors, but then nothing will be admitted until it becomes relevant.
Yes, Judge.
What was the other one?
That gone. That gone.
This also.
You want me to pick off?
Yeah, okay.
Yes.
I think she said she also wanted the date time taken off.
Do you want the date on this redaction, Judge, the date and time in the middle taken out?
Yes, and just remove that part, the entire section that has to do with booking.
Okay.
State, how many more witnesses do you have today after this witness?
This is the last one for today. Well, we have another one, but I don't think we're gonna get to them.
Okay, well, let's make this the last witness. And let me talk with Norma to let her know that we'll take up the other pleas. So everyone, just give me a moment.
Oh, good call.
She said the seal.
All right.
Thank you.
Good coloring job.
You're gonna graduate in the second grade.
Thank you. Feel so honored. Like that, don't you?
That's the one.
Got toasty? Got toasty during that argument?
I did actually, yeah. Got a little heated.
Okay, are you guys ready?
Yes, so
Yes.
Yes.
Can we remain without our jackets?
I'm fine with that. I mean, but here's the thing. I think it's best if one of you guys do it, all of you do it. Because otherwise it's gonna look weird. State, are you guys okay with not having your jackets on, or you want to keep your jackets
Leave
on?
mine on. I'm too sweaty already.
Okay. Well, you know what, John, you can keep your jacket off. I'll let the jurors know that I gave you all permission.
I have Mark's back.
All right, can we line them up?
I have it back.
All right, yeah, we're ready. Yes. Oh, excuse me, could you have your witness come back to take the witness stand?
So we can link location. So, Judge, just for the court and the defense, we might ask a few more questions about 33, 34, 35, 36, and 38, to not offer them right now, to not show them to the jury at all, but just to make sure our chain of custody found location predicate is done with this witness, and then not offer them so that we can follow up later.
Your Honor, I would object to that and request that we do that out of the presence of the jury. I have no objection to doing that, but I would ask that we do it out of the presence of the jury.
I'm sorry, just one moment. Deputy Norman, Laura, just give us 2 minutes. But John, it has to be done in front of the jurors. Because otherwise it's not
And I would
before them
ask
to
that we
consider.
bring this witness back at some later time, Your Honor.
All right, that'll be overruled.
So we're not going to show them, we're not going to offer them, we're just going to establish this witness that these items, we'll call them items. Witness, are you listening? When we show you states 33, 34, 35, let me just do this in the abundance of extreme.
Can we do this on the
specific
record?
Yes, we are on the record.
caution. Yeah, so witness. I'm showing you 33, 34, 35, 36, and 38. Can you look through those real quick? It's in. We're going to ask you, we're just going to call these items. Okay, we're going to say what they are in front of the jury. We're going to say, did you find these items? Where did you, well, do you recognize these items? Did you find these items? Where did you find these items? And that's going to be how we're going to refer to it. Okay?
Okay.
You okay with the word items?
Yes.
Okay.
And the same rules on those if you want.
Yes. We're also going to ask you the same on these 39, 40, 41. Did you find these items? Do you recognize these items? Where did you find these items?
Yes, sir.
All right, let's bring the jury in. Okay. All right, so the jury. Let me put your jacket back on. All right, everyone, please be seated. I'm being told that the air is coming on. You'll notice that it's cooler in the hallways than it is in here. So I think it's slowly making its way to us. All right, State, it's your witness.
May I approach, Judge?
Yes.
Officer Garrett, I'm re-showing you what's been marked. Exhibit 33, 34, 35, 36, 37A, and 38. Do you recognize those items?
Yes, sir.
Where did you find those items?
They were on the suspect's persons when I searched them.
And are the pictures 33 through 38, are they fair and accurate depictions of the items on April 27, 29?
Yes, sir.
I'm going to show you what's been marked as exhibit 39, 40, and 41. Do you recognize those items?
Yes, sir, I do.
Are you aware of where those items were found?
They're found in the backpack that was on SP1.
And is that the back? The backpack that we see in State's Exhibit 32?
Yes, sir.
So the items 39, 40, and 41 were all found in the backpack.
Yes, sir.
And did you bring, I guess, were you responsible for putting things in evidence?
Yes, sir, I was.
Did you bring anything with you that you put into evidence from that night?
Yes, sir. I got the bullets that were found inside the backpack.
You know, see. Mark it as case exhibit 2. And how do you know that this is what you put in evidence on that night?
Because we when we put stuff in evidence, we list underneath the barcode and it's registered under our name. And once it goes in there, it stays sealed until it's opened.
Okay. Is it still sealed the same way that it was when you put it into evidence?
It appears to be, yes.
Open States Exhibit 42. And can you look inside?
Yeah.
Are the contents of State's Exhibit 42 the same as when you, the similar, or the same or substantially the same as when you place them in
Yes,
evidence
sir.
on the tape? Have they been altered in any way?
No, sir.
And you said State's Exhibit 42 was found in the backpack.
Oh, yes, sir.
Officer, as officers with an officer with SAPD, do you wear any type of recording device?
Yes, sir. We wear body cams.
Your Honor, may I approach?
Yes.
At this time, the state will offer State's Exhibit 42 in evidence.
Any objection?
Your Honor, may we have an out of court hearing, please?
All right, just give us one moment, please. Ladies and gentlemen of the jury, you've heard evidence in this case. You're not allowed to deliberate or discuss anything that you've heard. Does everyone understand? All right, and today, after we complete this witness, I'm gonna give you a break and tell you what time I'll meet you here tomorrow, okay? All right, everyone, please rise for the jury.
40.
All right, well, please be seated. All right, there's an issue or an objection. No, it's States Exhibit 39 and 40. Yes.
Folder for the bullets out, you'll see that it is substantially more than the bullets that are in the photograph. I don't know what the difference is.
State.
Judge, I don't know the answer to that, but I guess my response to it would be that that's an issue for cross-examination. The officer laid the foundation for that evidence and said that it is.
So he's saying States Exhibit 39, which appears to only have 2, 4, 6, 8, 10 bullets. And then States Exhibit number 42 has 17, and that's the same?
That's what's notated in the report, actually. So I don't know what happened as far as the picture, but the report for Officer Garrett, and he can testify to it. Indicates that there was 17 rounds found for that exhibit.
So the officer is saying, I just want to be clear. So is the officer saying States Exhibit number 39 is the same as States Exhibit number 42? All right, is there anything else? I'll make my ruling on that. Is there anything else from?
No, Your Honor.
All right, and that's your only objection?
That is my objection, Your
All right, then States Exhibit, let me see, that was 39, 42, and what's the other exhibit number?
40.
States Exhibit number 39, 40, and 42 is admitted. And the court will admit those in the presence of the jury.
And do you have an objection? 41?
Well, no, we're not offering this one yet. This falls into the category of crap we have to do later.
Okay.
I hope that's not on the record. Thank you.
So that's 39, 40, and 42, correct?
Yes, Judge.
Yes, Judge.
But not 41 at this time.
All right, is there going to be any other objections before I bring the jury in?
The only other thing the state plans to offer is his body cam video.
All right, and we've already covered the objections of the body camera.
Yes, Your Honor.
All right. Is the jury in the hallway? Or are they taking a short break? If they're
there, they're just great restroom.
all right, if they're doing a break restroom, I'll take 2 pleas up and then we'll take,
Okay, so give them.
yes, 10 more minutes. All right, who are the parties on Enostrosa?
Is that what you say?
All right, is Sonny Middleton here?
Yes, Your Honor, I am.
Unmute, show your video.
Yes, ma'am.
Who is the prosecutor?
You're right, Judge.
Am I on mute?
No, ma'am.
All right, why are people not answering me?
Can you not hear me?
All right, thank you.
Oh, yeah, it's Joe Ray, Judge.
All right, who's the prosecutor on this?
Joe Ray.
Can you not hear us, Your Honor?
Yes, I hear you now.
It's
Can you-
Joe Ray.
Can you hear me, Judge?
Yes.
Okay.
All right, Mr. Enostrosa, if you could unmute, please.
Yes, that's me.
We have no AC here, guys. I'm hoping you have AC wherever you are. All right, the court is calling 2020 CR 5629W State of Texas versus Jose Enostrosa. Could I have parties announced for the record, please, for the state?
Joe Ray Garcia for the state.
Sonny Middleton for
defense?
the defense. Sonny Middleton for the defense, Your Honor.
All right, we're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Enostrosa, I'm showing you what's entitled defendant's consent to appear by video. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
Ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. The next document I'm showing you is entitled Waiver Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Did you understand that you have a right to have a grand jury indict this case? They will review the evidence and make a decision on indicting. Did you understand?
Yes.
Did you also understand your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of information to prepare for trial? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. And Mr. Enostrosa, those rights that I've just reviewed with you, did you intend to give those up and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Enostrosa, I'm showing you what's entitled information. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
State, are you proceeding on the information as presented?
Yes, Judge.
Mr. Enostrosa, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with assault, family choking, and strangulation? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Do you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison
Yes, ma'am.
and up to a $10,000 fine?
Yes. Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Enostrosa, how do you pronounce your last name? I'm sorry. You're on mute.
It's Enostrosa.
Enostrosa. Okay.
Yes, ma'am.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
All right. The court is in receipt of applications for deferred adjudication. Is Mr. Enostrosa applying for deferred or any type of probation?
No, Your Honor.
Next, I'm going to show you the page entitled Plea Bargain Agreement. Did you review that page with your attorney and did you understand it?
Yes.
According to the plea bargain agreement, the state is requesting your punishment be assessed at 4 years in the prison. There's a $1,000 fine. This is to run concurrent with 2020 CR 5629W. The state will take in consideration grand jury number 747168. There's an affirmative finding of family violence and no contact with Vivian Hernandez. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the entirety of the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
And the court will find for the record that the defendant knowingly and voluntarily waived his right to jury trial. State, do you have any evidence to support the defendant's no contest plea?
State offers State's Exhibit 1 and all its attachments.
No objection, Your Honor.
Mr. Enostrosa? I'm sorry, the A is removed on your paperwork. Mr. Enostrosa, did you review this document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find the defendant has knowingly and voluntarily consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Is there anything you wish to say on behalf of your client?
We would just like you to follow the plea bargain, Your Honor.
All right, the court will follow your plea bargain agreement, sentence you to 4 years in prison, give you credit for any time served. There's a $1,000 fine, money and time to run concurrent. This will run concurrent with 2020 CR 5629W. There's an affirmative finding of family violence. There's to be no contact with Vivian Hernandez. Next, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
Did anyone do paperwork in 2020 CR? Yes, I have it. Next, we're proceeding in 2020 CR 5629W. We're proceeding again by video because of the pandemic. Any objections, state or defense?
Your Honor.
No, Your Honor.
Mr. Enostrosa, did you review a document with your attorney entitled Defendant's Consent to Appear by Video? Did you understand it and did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm going to show you what's entitled Motion to Revoke Community Supervision and First Amended Motion to Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes.
Are you the same Jose Alfredo Enostrosa who's placed on community supervision for violation bond protective order 2 or more within 12 months on June 4, 2020 for a term of 5 years? Is that you?
Yes, Your Honor.
State.
On the first amended motion to revoke probation, violated condition number 1 on or about the 24th day of April 2021 in Bexar County, Texas, the defendant, Jose Alfredo Enostrosa, committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
True.
How do you plead to that? True or not true?
True.
State.
State waives the remaining allegations.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, sentence you to 5 years in prison? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes.
Court will find violation of condition number 1 true. Is there an agreement?
Yes, Your Honor. The agreement is for revocation to reform sentence from a term of 5 years prison to a term of 4.
Is that the agreement?
It is, Your Honor.
Mr. Enostrosa, are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes.
Court will follow your agreement. The court will sentence you to 4 years in the prison, give you credit for any time served, and there's affirmative finding of family violence. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
And in cause number 2021 CR 4925, and in cause number 2020 CR 5629W, because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
And because each of those cause numbers, you've been, there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
And I'm sorry. And cause number, just one moment. And cause number 2020 CR 5629W. There is also no harmful or injurious contact with Sherry Ann Marino. And with that, we'll close the record on your case. Mr. Enostrosa, you need to learn how to keep your hands to yourself. Either you want to be in prison for the rest of your life, in and out of prison, or either you don't. I don't know, I guess in kindergarten or preschool or wherever it is, you didn't learn that you're not supposed to put your hands on someone in anger. Do you understand?
Yes, Your Honor.
Make better choices. Good luck.
Thank you.
You're welcome. Who are the attorneys on Ray Lynn Wheeler?
Hunter Morris for the state, Judge.
Luis Martinez for defense.
Ms. Middleton, thank you for your patience. Court is calling 2020 CR 10201, State of Texas versus Ray Lynn Wheeler. Can I have parties announced for the record, please, for the state?
Hunter Morris for the state.
For the defense?
Luis Martinez on behalf of Mr. Wheeler.
And are you Mr. Wheeler? Could you unmute, please?
Yes, ma'am.
Yes, we're proceeding by video because of the pandemic. Any objections from the state or the defense?
None from the state, Judge.
None for the defense, Your Honor.
Mr. Wheeler, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge, we do.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Counsel, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, ma'am, I did.
Court will find that the state is in compliance with discovery. Mr. Wheeler, I'm showing you what's entitled application for community supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
And did you electronically sign it?
Yes, ma'am.
Next, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand what you're charged with is felon in possession of a firearm? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargaining agreement you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea bargaining agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor, yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he was.
Mr.
And I
Wheeler,
believe he
has
is
anyone
now.
threatened you? Thank you. Mr. Wheeler, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than a plea bargaining agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Very much so.
Are you a U.S. citizen?
Yes.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargaining page. Did you review that page with your attorney, and did you understand it?
Yes, ma'am.
According to the plea bargaining agreement, there's to be a $1,500 fine. The state is requesting that your punishment be assessed at 2 years in the prison. The state is recommending community supervision. Did you understand that to be the plea bargaining agreement?
Yes, ma'am.
Defense is at the plea bargaining agreement.
Judge, that's our plea bargain.
State is at the plea bargaining agreement.
It is, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places? Mr. Wheeler, you're muted.
Oh, yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Judge, can you repeat that? I can't hear you very well.
Have there been any such motions?
No, Judge, there have not.
Next, I'm showing you outside the plea bargaining agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 100 hours of community service restitution. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations? Mr. Wheeler.
Yes, ma'am.
Then to the offense is charged in the indictment. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
State overstates one of the attachments.
And that's without objection, Judge.
All right, Mr. Will, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulation. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court is accepting into evidence states exhibits 1 and attachments, and the court has reviewed those exhibits. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Judge, we're prepared to just proceed to sentencing at this point.
Anything you wish to say on behalf of your client?
Judge, we're very fortunate the state's given a reasonable plea bargain. Obviously, Mr. Wheeler is indigent and he's in custody right now. He's eager to get started on this probation, and to that end, we would ask the court to consider probating a portion of that $1,500 fine.
All right, Mr. Wheeler, are you employed? Do you have any employment?
No, ma'am.
When's the last time you worked?
It's been a while. I can't really remember. It's been a little while now.
Why are you not working?
I was a drug addict.
Okay. And what was your drug of choice?
For the last year, I did meth and heroin.
Do you have any children?
Yes, ma'am, but they're all grown now.
All right, where are you going to be living if you're released?
I'm gonna be living here for the meanwhile. I guess I'm gonna try to get to Oklahoma though after a while.
No, do you have a place to stay, a physical location?
Yes, ma'am, I do.
All right, this is what the court is going to do. The court will sentence you to a $1,500 fine that will be probated. Sentence you to 2 years in prison, suspended and probated for 2 years. 100 hours of community service restitution, or you can pay $7.25 per hour to the San Antonio Food Bank. Intensive outpatient treatment with probation. Proof of employment within 30 days of release. No employment as a home health care provider or any employment that involves the supervision of minors. Field visits, random, 3 times per month. Regular reporting by Zoom or in person. Rebecca, is there anything else that he needs?
Are you gonna do random drug tests?
Yes. Random UAs. I want to do the UA hotline, but I don't believe he'll be able to afford that until he's employed. All right, Mr. Wheeler, is there anything else you need from the court in order to be successful?
No, ma'am, but I am gonna get copies of all that, and I'll have
Yes, you are.
know what to do. Okay, so I'll know what to do.
All right, did you review this document entitled Trial Court Certification of Defendant's Rights to Appeal? And did you sign it?
Yes.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record, Mr. Wheeler. I'm giving you all the tools you need in order to be successful. Whether you take advantage of that or not is completely on you. If you don't want to find yourself continuing to use drugs, going in and out of prison, you should take advantage of that. And I'm going to tell you what I tell everybody else. You never know what you're getting when you're getting drugs. It's not it's not stamped by the Federal Drug and Food Administration. It's just people in their kitchens or wherever they may be mixing things together. Do you understand?
Yes, I do.
All right, I'm going to open rooms, and I'm going to send you to breakout room number 2, Mr. Wheeler, so don't leave until I send you to 2. And Rebecca, if you could go to 2.
Yes, ma'am.
All right, could you bring the jury back in, please?
Excused?
Yes, thank you for your patience. Yes. be seated. State that it's your witness.
Thank you, Judge. May I approach the witness?
Yes.
What's been marked and admitted as State's Exhibit 39 and 40. Can you tell the jury if what's depicted in 39 and 40 the same as was found in State's Exhibit 42?
It's different.
It's different?
Yes, sir.
How is it different?
Excuse me, I'm gonna get you to speak up so that.
Yeah, I'm sorry, Your Honor.
And the jurors can hear.
It's different because there's more bullets in here than in the photo.
Okay. And in your police report for that day, would you have logged that in as property that you found?
Yes, sir.
Could you look at your report from that day and tell the jury how many bullets you found in the box?
In my report, I wrote that I found 17 bullets in the box.
Okay. And is that how many is currently in the box right now?
Yes, sir.
And were you responsible for taking the pictures for 39 and 40?
No, sir.
Was that one of the CSI people?
Yes, sir.
But when you put the box in the evidence, it had 17 rounds in it, correct?
Yes, sir.
And what type of caliber are these rounds?
They're 9mm.
Would they have hit the firearm that was found at the scene?
I do not know, sir.
Did you take the firearm into custody?
No, sir. No, sir.
And earlier you stated that officers with SAPD were body cam. Is it capable of making accurate recording of the events as they occur?
Yes, sir.
Did you review your body cam for this case?
I did, sir.
Was everything depicted in the body cam correct, and was it a true and accurate copy of the events as they occurred on that day?
Yes, sir.
And State's Exhibit 23, is this a copy of your body cam?
Yes, sir.
And how do you know that it's a copy of your body cam?
I signed it.
Your Honor, at this time, we will offer State's Exhibit 23 subject to the agreed redaction.
All right, State's Exhibit, I'm sorry, defense.
No objection, Your Honor.
All right, then State's Exhibit number 23 is admitted.
And I'm gonna fast forward to the time. Okay, I'm fast forwarding to timestamp 4:25:07 in the video.
I got stabbed over here. Knives here, guns on the porch, but now it's 340's got the gun. Yeah, 340's got the gun.
Your Honor.
Wait, someone check for bullet holes and casings. I guess he's getting shot. I don't know where at.
Yes.
In the redactions that we discussed, Your Honor, one of them was the discussions of the officers. And that's obviously the officers discussing the charges.
All right, it was the court's understanding that the beginning of the video was allowed. Can I have a party's approach, please?
Officer Garrett, at this point, is the defendant already in handcuffs?
Yes, sir.
And is he, I guess, below the view of the body cam?
Yes, sir. I'm standing next.
I'm gonna start the video back at 4:25:20.
This guy said in the half said he got shot at, but I don't know where the casings are, so. EMS? You got an idea? That is regular. I was saying, nothing in his car, but nothing to take it. That's what he's saying.
Did he just say in the video that nothing was taken from the car?
Yes.
I was outside. I was outside, man. That's fucking bullshit. That's fucking bullshit. I almost died.
So what are you doing in their yard?
I was down.
Sat down in their yard?
And that's the rest of my thing, he got on my back and I couldn't fucking breathe. That's another one I have right on the side. And it's going too much. I can't take it. I didn't know. Let's see.
We're going to have a public on my one 2024 before the church island.
James. Hold there. Step
I had to defend myself.
EMS? What's up? Do you need EMS? Yeah, I got it.
Oh, guys, taking my ass. Oh, niggas, full time. Thanks for already 2 of them, guys.
I have a fucking head back there. Shit, they don't know it's a bullshit.
What's your name? What's your name? What's your name? Kevin? What's up? You wanna go back home? Where you live? So there was two.
I'm resting away. Resting away.
They pointed at you and you wrestled the gun away?
Shot.
And shot?
I swear to God.
Do you know where you were standing when it shot? You're standing over here?
It started right at that time. Over there. Yeah, I agree. We had a fighter. Ain't got one girl. Are you fucking serious? I have fucking done well twice, and I had to fucking defend myself. I'm so I got fucking a gun pulled out. I went away, so I went out supposed to get shot. I sat down. Then I was about to get up. Why are you sitting on this driveway? It was right there. It's not, that's not considered Berkeley. If I'm sitting down on the ground, I sat down and take a breather. And then I looked up and that's when it came.
So what's in your backpack?
Oh,
That's it. No burglary tools, no screwdrivers, nothing like
no,
that.
I don't do none of that.
No.
Where's it? Huh?
That's right now.
That's what I'm saying. I said perfect. And I got my ass a gun for it. Are you serious?
Okay, guys, hold on here.
I don't know. I was going to shoot this bit of choke. That's what I seen it. It was right here. It was right on the ground. I sat down. That's all I fucking said. That was the place I took the set. You read about seven. Remember I got sent to? I'm the one fucking marching around and said, I said,
Now I'm gonna fast forward to 4:49 in the video. At 4:49 and 25 seconds. Officer Garrett, can you tell the jury what's going on in this picture or in this still?
So I'm lifting him up to take him to the vehicle.
Who is that behind you? Who is he? Play it.
And the CSI was on scene.
Okay, is that when she was doing the GSR?
Yes.
What's up? So we get 371's car pulled up here. Okay, but you left her right-handed. Right. Station under is trying to beat up.
What do you need for work? What do you need for work? Looking for work. Jack Bear. Bear thirst. That's a shooting. What have you done? I only got shot at.
I'm stopping at 4:50:52. I'm gonna fast forward to 5:07. At 5:06:48.
The young man has him by his hand because I him when they took him for the gun. Left hand. Left hand.
You missed
So did he just tell you that he bit the person's hand who was holding the gun?
Yes, sir.
And are you aware of which individual was bitten?
No, sir.
And lastly, I'm going to fast forward to 5:24. Stopped it at 5:07:31. That I stopped it. 21. Or no, sorry, 31. It was 31. Okay, 5:24:11 is where I'm starting.
Was it in this yard right here?
Yeah, it was right there. It started, I was sitting right there by that turn where that little bag thing is. That's when he jumped on me, drugged me into the ground.
Did you just say that he was drugged to the ground?
Yes.
Then he called for the other dude. That's when they started telling me, that's when I seen the thing. And I bit him, and it was here, pow! Then they tried to put it right here, push it again.
You know which way the gun was pointing when it went off? Right
Yeah, toward the
house.
fire trees. That shit went up on my face, and I'm in jail for defending myself.
Stopping the video at 5:25:04. I'll pass the witness, Judge.
All right, defense.
Roll, please, Your Honor. Did Mr. Debnab resist your attempting to take him into custody?
No, sir.
Did Mr. Debnam consistently say that he was attacked by these people?
Yes, sir.
No further questions, Your Honor.
State.
Judge, may we approach?
Yes.
No further questions, Judge.
No further questions, Your Honor.
Excuse from the state. Actually, I'm sorry, Judge, actually subject to recall.
Ladies and gentlemen, jury, this is where we're going to take our break. A lot of things have happened as far as with the temperature. That we will break at 4:30. I'll meet you here tomorrow at 10. I have other matters to take up on other cases at that time. So from 9 to 10, I'll take up those matters. And while you've been on break, the court was able to handle matters involving other cases. So even though we have this jury trial going on, I still have other cases that I must take care of. I've said it before, and I'm going to say it each time you leave here. You are not to discuss anything that you heard. Don't roll it around in your brain. You're not to discuss with anyone. You're not to discuss amongst yourself any of the testimony that you heard. Does everyone understand? I don't expect this to appear on television, but if it's possible, you never know. If you see anything about this case on anything, turn it off, go to another room. All right, does everyone understand? And again, we can't start at 10 unless everyone's here at the same time. Okay? All right, everyone, please rise for the jury. Everyone, please be seated.